Okay, so hello and good evening. Welcome to the launch of the Electronic Wills and Online Witnessing Committee. We'd like to thank you all for joining us at our inaugural event. I'm Carol Grimshaw, the co-chair of EWOWC, and yes, it is pronounced just like the George Lucas creature. We would also like to make a statement in the spirit of reconciliation that our parent, the ACLI, the Australasian Cyber Law Institute, and EWOWC acknowledge the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respects to their elders, past, present, and emerging. And we extend that respect to all Aboriginal and Torres Strait Islander peoples today. We are joined this evening by some very esteemed guests from across a wide range of the legal and tech communities. In particular, the Victorian Civil Administrative Tribunal, the Legal Practitioners Liability Committee, Office of Chief Parliamentary Counsel, and members of the Attorney General's Department within Victoria and the Northern Territory, and many of the mid-tier firms who have decided to join us this afternoon, as well as other senior legal policy and thought leaders. We have a wonderful panel for you this evening with my EWOWC co-chair Peter Moran as our moderator. I should say a little bit about EWOWC. We formed as a working group of the Australasian Cyber Law Institute in about June this year in response to the legislation that had started to be issued throughout the Australasian region for electronic wills and online witnessing. With the purpose of ensuring the provisions were backed with robust procedures, we're a group of lawyers, research, ethics professionals, technical professionals, and law students interested in working toward making permanent the current provisions which are set to expire in Victoria on the 26th of April 2021. We welcome you here this evening to hear from our panel about whether that should at all be possible. To help me with your welcome and introduce you to our panellists is our very generous sponsor from the very modern, smart and adaptable Young's List, Ms. Tammy Young. Tammy?
Thanks, Carol. Young's List is delighted to sponsor the launch of EWOWC today. Our barristers have particularly embraced technology in their practices, and to that end have most recently joined with eBrief to facilitate electronic briefs. When the EWOWC committee approached me about the launch today, I was excited about the potential of legal developments in this space, as I'm sure you are too. EWOWC have an exciting lineup today and in the future of events to guide discussion around the developments of policy legislation and frameworks, which will enable robust processes for the electronic execution of wills, powers of attorney and other legal documents requiring witnesses. Thank you once again to the EWOWC committee for the opportunity to participate today.
Thanks so much, Tammy, and thank you, Carol, for that intro. Hello, everyone. I'm Peter Moran. I'm one of the co-chair of EWOWC together with Carol. Welcome to this evening's event, the first event of EWOWC. As you heard from Carol, we're only a couple of months old, so we've only been going, and it's fantastic to have you join us. It's an area that is really needed for discussion at the moment, hence why EWOWC was created. Tonight, we've got a great panel, and we'll jump into our discussion. I'll introduce the panel shortly, but just to explain the format for this evening, because part of the point of EWOWC and what we're trying to do with this sort of challenging space of electronic wills and online witnessing is allow an opportunity for practitioners and others in the space to talk about their experiences, to ask their questions, to work through the challenges of this, because for sort of everyone, we are in very uncharted territory. Until recently, wills were not explicitly permitted to be electronic in most jurisdictions, in all jurisdictions in Australia. So we're in a whole new world. And so what we're trying to do to facilitate that discussion is have a virtual town hall. Now, ordinarily, we'd be able to sit all in a room and have a microphone and pass it around for people to participate. Today, we're trying to do something a bit different with Zoom. You'll see that we're in Zoom webinar where we have the panel talking to you, and you as attendees are fairly passive at the moment, just watching us. What we will ask to do at times is allow people to be brought across as panellists and speak and ask their question or share their experience. Now, in registering, many of you actually put questions to us, and we will try and get through those questions as we go through. And what I will do is actually name the person who has asked that question or has raised that issue. And once the panel's been through it, if the person who's asked the question would like to then respond or clarify or speak to the answer to the question, what we'd ask you to do is just to raise your virtual hand. So you'll find in your function there, you have the ability to raise your hand. So if you just click on the raise your hand, or even just mention in the Q&A that yes, you'd like to speak, and Sharon, our wonderful tech whiz, will bring you across to the panel, and you'll be able to speak, and we'll be able to see you, and you'll have an opportunity to talk. We're intending to sort of have the panel discussion for 45 minutes or so, and then we will open up the town hall side of the event. And what we'd like to be able to do is give everyone their opportunity, or not everyone, unfortunately we have so many registered that we would be here for a very long time, but allow some people to share their experiences or raise their questions. So if you have questions as you go along, or if you have an experience that you think is relevant to the discussion, please enter that into the Q&A function. Now with Zoom webinar, there's two systems. There's a chat and there's a Q&A. Now chat, you can chat to each other or whatever, but we won't be looking at that. We'll be looking at the Q&A. So if you please sort of type your question or your comment, or you'd say you'd like to be able to sort of speak to that, please put that in the Q&A function, and when we get to the town hall, we'll talk to that. I'm going to open when I get there we've got a number of other EWOC committee members who are here, and just be warned, EWOC committee members, I'm going to call on you to talk at the start of the town hall to sort of share your experiences. But hopefully we'll get a good cross-section of people to sort of talk about you know, successes they've had with electronic wills, challenges, frustrations, etc. We're here to sort of share all of our experiences. There is no judgment tonight in this environment. So to turn to our panel, we've got a great panel. We've very deliberately tried to choose a sort of a cross-section of people to talk to, I guess, a range of the challenges that we're finding here. So, and I should say to begin with, I'm not a wills specialist. I've drafted wills, but that's not my area. I have an interest in electronic contracts, and that's been a thing I've worked in a lot, and that's sort of how I've got drawn into this space. But we do have a wills expert tonight on the panel in Naomi Guyett. Naomi is a senior associate at Lorraine, Jones and Associates. She's an accredited wills and estate specialist. She's practiced exclusively in the area of wills for 20 years. She sits on the Specialist Accreditation Committee at the LIV. She's co-chair of that committee. And I have to say, Naomi taught me about wills. Many years ago, I did the Leo Cusson wills course and was taught wonderfully by Naomi, and she still teaches that course today. And she is, I think, one of our preeminent wills lawyers. So it's great to have Naomi on our panel tonight to share experiences. We also have Jennie Pakula. Jennie and I have worked very closely at the Law Institute Innovation Committee. Jennie is the Manager of Innovation and Consumer Engagement at the Victorian Legal Services Board and Commissioner. She's worked in legal services regulation since 1994 and has held various roles in both New South Wales and Victoria. Jennie is a wonderful champion of innovation in the legal profession. And it's really interesting to see the role of a regulator in helping encourage practitioners to innovate and to challenge themselves and find new ways to deliver really good customer service. And we're really looking forward to hearing Jennie's views about some of these issues and the topic today. And finally, our third panellist is David Bowles. David sits and is a founding board member of the Australasian Cyber Law Institute, ACLI, as am I. But he also had his day job is as the ethics solicitor at Queensland Law Society. David was admitted as a solicitor in 1996 and was in private practice until he joined QLS Ethics and Community Practice in November 2012. He has experience, obviously, as an employee and also as a sole practitioner and interest in areas of crime, property, litigation and estate planning. So welcome, everyone. Great to have you joining us today virtually. We can't all be in the room, but great to have you from Queensland, David, and Jennie and Naomi in Melbourne. What I'd like to sort of start off with is just, I guess, set the scene a little bit for everyone. We're not intending for this to be a CPD session, and we're not intending to sort of go through the laws in detail. We will give a bit of a brief background of our understanding of the three regimes on the eastern seaboard, so Victoria, New South Wales and Queensland. And then we're just going to jump in and sort of talk through what we think are sort of a range of issues and challenges, both with the specifics of electronic wills, but just in terms of the regulatory environment and the ethics and how we sort of try and juggle these sort of challenges as practitioners. So before we sort of jump in, and I'm going to ask Naomi to, I guess, walk us through the Victorian regime as it currently stands. But I just want to remind everyone that the COVID regime that we sort of got brought to us doesn't exist in a complete vacuum. And it's not that we haven't had electronic documents and electronic signing before COVID. We actually have an Electronic Transactions Act regime that has been with us since 2000, and that's a regime that we've got in every state and federally as well. And it's a fairly unified regime that governs electronic transactions, including electronic documents. Interestingly, in Victoria, wills were explicitly carved out from that regime in 2010. So that's been one of the reasons that we've had this sort of funny dichotomy with wills not being part of the sort of other electronic environment. But in the recent times, there's been discussions around how we might embrace these processes for documents like wills and powers of attorney and affidavits, which has also been another area of challenge for courts, because a lot of commercial contracts and a lot of documents are these days being executed and circulated electronically. So that was the scene, and then COVID hit, and then governments realised we really needed to deal with some of these issues, and we got these COVID regimes. So Naomi, I might throw to you now, and if you could just walk us through your sort of understanding of the Victorian regime, specifically around electronic wills.
Thanks, Peter, and welcome everyone. So obviously, well, sort of start off by saying that typically as a wills practitioner, we know that face-to-face meetings is the best way to establish capacity, confirm identification, to ensure there's no undue influence, all of those subcategories that we as practitioners need to satisfy ourselves about when we're taking instructions and meeting with the clients. But we've also got that duty to provide legal documents, especially the will, to our clients. And these long-established sort of principles about the formal requirements that we need to adhere to for wills sort of were thrown out the window in the traditional wet ink sense when COVID, you know, came to be part of our community. And we had to revisit all of these signing and witnessing requirements, and that really threw us into the world of technology, because as we know, wills are a very paper-based area of practice and has been slow to adapt to technology that has been available in other areas, such as property and such as the commercial backgrounds. And so the COVID-19 Omnibus Emergency Measures Electronic Signing Witnessing Regulations, it's a bit of a mouthful, there's no acronym for that, was passed and came into operation on the 12th of May this year, and that's running for 6 months. And we have the potential, and there's discussion now that 6 months, which will be the 24th of October, that will be likely to be extended, given that we're still technically in stage 4 at the moment. But interesting, prior to that, New South Wales led the way and in fact passed their regulations, their own regulations for remote witnessing of wills in April of 2020. Queensland followed suit in the same month that they were able to have remote signing. So we already had other states passing these regulations to allow us to remote sign so that we could still assist our clients. And this avoided the problem horror stories we would hear of back in the height of the pandemic, in that first stage, where practitioners were, you know, reluctant to meet with clients. Clients were reluctant to meet with us. And we were hearing stories of the sort of drive-by Macca's type scenario where clients would pull up in their cars, the practitioner would pass the will out across the window, and we're signing and witnessing, and then they're driving off. So the regulations were a welcome introduction to avoid that sort of contact that we still, you know, felt that we needed to have. But have we got it right? Should we bother? These are the questions that we're going to discuss more tonight, I think, because the regulations that Victoria has are certainly much more complicated, and so many more steps that are involved as compared with the regulations in New South Wales and Queensland. And look, they're not going to be suitable for every client, but for the majority of our clients who, you know, have the convenience and are able to adapt to the technology that we're introducing them to, if they have scanners and printers, for example, then, you know, there's no reason why they can't sign the documents electronically. But as I said, there's a final step in our Victorian regulations that we have that involves having the will, once it has been remotely signed by the will maker and the two witnesses. We as practitioners then have to provide the will back to the will maker to say, is this what you just signed 3 minutes ago? Is this still the same type of version? And have a statement that's written onto the will to confirm that. And I think that's puzzling practitioners a lot, because New South Wales don't need to do that, Queensland don't need to do that. And interestingly, there was a poll that the Law Institute ran recently whilst there was an educational webinar based on the regulations and introducing the practitioners so they were familiar with those regulations. And the poll was given to the attendees. The first question was, should the regulations become permanent? And 59% responded saying yes, they should be in the affirmative. So there is support out there for having electronic wills and witnessing requirements to be adopted on a permanent basis. But the next question then was posed to the same group of practitioners. Okay, you're aware of the regulations. Have you remotely witnessed or signed a document since the regulations came into effect? And a staggering 91% said no. And the big question is why. Obviously, the poll didn't go on to ask why haven't you, because there could be a wide-ranging a number of reasons. But from my observations and what I've heard from other practitioners, a lot of that rationale comes down to, I haven't taken up the regulations because A, they're too complicated, B, the clients find them too complicated, and C, they're very too time consuming for wills that are typically a market-driven fixed price type content. And the regulations also don't allow us to remotely sign medical treatment documents or binding death benefit nominations, which in a lot of our packages that we offer to clients are part of the package. So it seems a bit silly that, all right, we'll get your will signed, we'll get your powers of attorney signed, but we can't get you to sign your medical treatment documents that we've still drafted or your binding death benefit nominations for your self-managed super fund, for example, because the regulations don't extend to allow remote witnessing of those. So there's a lot of conundrums in the way that are perhaps part of the reason why there hasn't been a big uptake on the regulations.
Naomi, can I ask you a question before I then ask David about what's going on in Queensland? But the legislation, as I read, particularly wills, it sort of strikes me a bit that it's not drafted with an electronic signing process in mind in terms of a DocuSign or an EchoSign or Adobe Sign or any of those processes. It's more envisaging that people will use an email and a scanner and that sort of system. We obviously earlier in the year did our own sort of demonstration, almost our sort of preliminary EWOC event, where we did an online signing process using Zoom and using DocuSign to sort of explain how that can sort of be used. Do you think that process will fit with the current regulations, or is it because it's not really designed for that process, and there's this concept of having to write on it how you did it after the event that it's too unwieldy to use something like a DocuSign and a Zoom?
I think the technology is there with DocuSign so that you are able to avoid the pass the parcel, what I call the pass the parcel approach, which the regulations set out, because the regulations are talking about I'll email it to you, then we'll set up a link, then we'll get you to sign it, then you email it back to me. And this has all got to happen on the same day, of course. So they've got to have the ability to scan and return it back to the witness one. Witness one signs, then passes it back to witness two. And then it's got to go back to the will maker for a third and final time. So I think that's very off-putting for practitioners to implement. And clients can easily get sort of confused around that pass the parcel concept. With something like DocuSign or HelloSign, or those new platforms that, well, they're new for wills practitioners, but something like DocuSign's been around for a number of years and is being used in the corporate practice area. But that can avoid the pass the parcel issue, because you've got the document uploaded, you can share your screen via Zoom. You can have another person invited to that meeting as the second witness, and they're able to place their signatures then there and then on the document. And I think that gets you around that whole, what I call the pass the parcel approach, and will still be valid and accepted under the regulations.
Right. Thank you, Naomi. David, share with us what's going on in Queensland in this space.
Sure, thanks for that, Peter. Before I do that, I do need to stress that I'm wearing my ACLI hat tonight. So my opinions and errors are my own, and I don't purport to speak for the Law Society, although I don't think anything I'll say is going to be too controversial. So we have two systems running side by side. The first response to COVID was Practice Direction 10 of 2020, which essentially was the court responding as well as it could without a regulatory change to essentially direct the probate registrar that they could admit to probate documents which were formally compliant in everything except having physical witnesses, and then a few additional steps were put in place as well. As far as I know, we don't have accurate numbers on this, but as far as I know, there is no practitioner that actually used that. Although there were certainly some early indications that that would be necessary, largely in part, I think, because the regulations then changed a little bit later in the month. So anyone who was interested in the practice direction, that it actually expires in about 4 hours. So it's going to be largely historical, no real need to get your head around it, I don't think. Our regulatory response is based around this concept of special witness. So we have only certain people who can act as witnesses under this regime. So one of those is Australian legal practitioners, JPs who've received additional approval and certification, JPs in the presence, in the employee of a legal practice. And that's, as far as I know, there aren't any approved JPs as yet, but certainly there are a number in the pipeline, and there's a process being set up to approve them. So it's been kept fairly tightly prescribed to legal practitioners, essentially. The documents which are covered include stat decks and deeds, and they expressly can be electronic. Wills and EPOAs, and they are, there's no mention of them being signed in electronic form. So I think the Conservative position has been that we don't really have an electronic wills regime. What we have is a remote witnessing regime, which allows you to witness using audio-visual system. I've had a few people that have earnestly told me that, based on the definition in the regulations, that actually encompasses a electronic document as well. I must say, I think some of those arguments are reasonably convincing, although the difficulty will be, of course, that all of the classes of documents which, so specifically stat decks and deeds, they expressly state that it can be signed electronically, and there's deafening silence in relation to wills and EPOAs. So I think the express inclusions rule probably would make anyone wanting to rely on an electronic will shall we say, brave. And I haven't spoken to any practitioners who want to be the first wildebeest over the river on that one. So
we're still waiting in Victoria as well.
Right. We all grew up watching David Attenborough. We know what happens to those that are the first, you know, first near the crocodiles. So at the moment, what we have is effectively a system where the will or enduring document is wet signed, you watch it, or we have another process where the testator or the donor authorises a person who is in your presence, and then you watch that authorisation and verification process. That's a little bit convoluted, and as far as I know, not many people are using that, because effectively the solicitor ends up with two sets of obligations, one to the person on the other end of the line, one to supervise the person in the room and to make sure that they are not within, you know, certain classifications of relationship to the donor, etc. So the system which is being used, albeit from what we understand not all that often, is where the document is given to the testator. They have a physical copy with them. They then sign it. The solicitor then witnesses that signing using a stable AV system, satisfies themselves of certain things. Interestingly, they are required to satisfy themselves and to certify that in their view there is no undue influence being exercised on the testator or the person granting the power of attorney. That causes a little concern, of course, because we can take reasonable steps to do that. You can never exclude that possibility either in real life or virtually. So some practitioners have been a little concerned about what they see as a transfer of responsibility in that respect. I'm not sure that I think that it really changes the current situation that we have. It just makes it a little more perhaps complicated. Then we have a similar process where the witness must get their hands on an electronic copy of what has been signed. They endorse that and then they give that back to the original person. So we end up with a little bit of a compendium of documents, and there's a question about, you know, what is the will, whether it is the one that was wet signed, whether it's the one that was then imaged, sent to the witness and then endorsed by the witness, or the document which was returned back. I think once again, the smart money simply says that it's the compendium, you get your hands on all of them and you keep them together in a bundle along with the certificate of the process that the regulations require that the solicitor signs. The two sort of points that I think would concern legal practitioners are that they must be reasonably satisfied of the absence of coercion or undue influence, and also there's an express statement that you've got to verify the identity of the signatory. Both of those things are, in my view, not impossible to discharge to a reasonable standard and to take any risks involved in that down to a, you know, an acceptable commercial level. Of course, it's always impossible to exclude either of those things. And so if a solicitor is, you know, gets very focused on those two elements, then effectively this regime essentially becomes impossible for them to manage, because you do have to accept the fact that I'm not sure that the risk levels are particularly higher, but certainly they are slightly different. And of course, it's generally easier to pull a fast one remotely, whether it's, you know, by email or by telephone, etc., than necessarily face-to-face. So, you know, there is always, I think, a slightly increased fraud risk when you're dealing with the digital economy. But again, I think that's certainly manageable. And I would think that the commercial imperative on solicitors to offer this service is probably going to make it a necessary commercial imperative that we learn to deal with those concerns.
Thanks, David. I'll just quickly talk to New South Wales, and then I want to throw to Jennie, and I guess get the perspective of a regulator and all of this, because David talked about the fear of being the first. Someone's going to have to do it. New South Wales, as Naomi mentioned, were the first to move with this, and blows me away that they were the first to move, and they got it, I think, the best, in that they produced a very short regulation under the Electronic Transactions Act, regime, and they passed a regulation that dealt with, in one sweeping document, wills, powers of attorneys, deeds, enduring guardianship appointments, affidavits, and statutory declarations. And they set out and they really said, this is just dealing with the witnessing and attestation process, and for doing it via an audio-visual link. And they just set out some very sort of clear guidelines around what's required for that. And really, there's 4 simple points. That one, that the witness needs to be reasonably satisfied that the document being signed is the same as the document that they're signing. So they've got to be satisfied that it's the same document. They've got to observe the person signing the document in real time. So obviously using Zoom or a similar sort of system. Sign the document or a copy of the document as witness. And I think that's helpful because one thing that is going to have to be resolved by the law with all of this is what is an original document in the context of something that's been signed via such a DocuSign process, for example. I think that the notion of a copy becomes really difficult in that environment. So that issue doesn't even crop up as it does in the Victorian regime. And then finally endorse the document or a copy of it with a statement specifying the method that was used to witness it, which is actually a requirement of the Electronic Transactions Act anyway, in terms of that the parties have agreed to the method by which it was done. So it's pretty simple and straightforward, and I think aligns with what was going on already with the electronic signing regime. So for all those practitioners in New South Wales, enjoy. You've got, I think, a much clearer regime. And interestingly, that regime was due to sunset in a couple of days, and the New South Wales government saw fit a couple of weeks ago to extend that regime out until March next year. So New South Wales practitioners very clearly have that regime through to at least March. And I would be surprised, given how sort of elegant and straightforward that regime is, that there isn't a good argument to make it even more permanent. So that's the situation across the Eastern Seaboard. Apologies for the other states. We would be here all day if we covered off every state, but we're giving you a snapshot of the Eastern Seaboard. Jennie, I'd like to ask you now about, I guess, the perspective of a regulator, because I guess as practitioners, we're all very worried that, are we complying here? If we try and follow this process, it's a brave new world for all of us, particularly those who are not familiar with a system like a DocuSign or have not executed something in an electronic method before. And we get it wrong. If it turns out that part of it we don't quite follow. No doubt we've said to our clients at the time, this is new and hasn't been tested in the courts. There is uncertainty here, but we will try our best. What is the perspective of a regulator going to be if ultimately a document like this is not enforceable, there's complaints made or whatever? What do you think is going to be your perspective?
Thanks, Peter. Look, I think one of the things that often comes up when I talk to lawyers about the implications of doing something differently and what the regulator thinks of it is, I guess, a bit of a misplaced sense of risk around the risk of getting disciplined for it. So if something goes wrong, is it automatically going to be unsatisfactory professional conduct or professional misconduct? Well, I would want to say very, very clearly that if you do your best, if you inform the client about what's going on, what are the implications of it, and if you get relevant advice to make sure that you do it as best you can, that's what we're really concerned about in terms of the conduct of the matter, and the conduct of the lawyer. So I just want to make it really clear that just because something goes wrong, it doesn't necessarily mean it's going to be a conduct issue. If it goes wrong because you royally stuffed it up and you didn't take any careful measures to make sure that you got it as good as you could, that might be another thing. But it's really a matter of getting the right advice, trying your best and doing your best. I think in these circumstances, they're very unusual circumstances that we're faced with. And this is a regime of execution that a lot of people are unfamiliar with. So I think it's very important to note that we're not looking to pounce on people if something goes wrong. And really also, you don't want to do something like not do a will for a client because you're worried about getting in trouble. The most important thing that you need to do is serve your client's interests and help them to have a will. I mean, I think this is one of the things that comes across all throughout the case law is the importance of people being able to declare their testamentary intentions. So what you need to do is try to follow the regime as best you can, but most importantly, try to make sure that your client gets the will that they need and gets their testamentary intentions expressed.
Great, thank you, Jenny. Naomi, I might throw to you. Can you imagine a circumstance outside of COVID where electronic signing of a will might be your preferred approach? Like what would be the examples where you could see this could have utility beyond us all being locked at home?
Look, I think with the more sophisticated clients, and I've, you know, everyone's almost sick of Zoom, but clients aren't sick of Zoom because they don't have to come into the office anymore. They have to pay for city parking that's $80 for 15 minutes. You know, they can do it from the convenience of their own home. They can meet with you there. They can sign with you after hours if need be. So I think there is merit in, you know, having it beyond, not just thinking of as a COVID, all right, let's wait till COVID finishes and then we'll go back to wet ink traditional methods. And that will be okay for some. I'm not advocating that remote witnessing is going to work for everyone, but I think Zooms or you know, equivalent Skype type meetings where you have that virtual meeting with the client is much more convenient, you know, for the clients. And so I think they're appreciating that we're available to them via that means rather than them having to come to us in a face-to-face on-site, you know, business premises. So there is certainly merit in having these around for the more sophisticated clients, notably. Time poor, people are very time poor. It's hard enough to get people to do their wills, you know, and think about death and disability at the best of times, let alone them having to, you know, take time off work to come into the office. So the ability to be able to do it remotely is an added convenience that the clients certainly appreciate.
What about then the bookend to that, the situation where there's just a real problem with either access to the technology or the ability to use the technology, or there's simply just a resistance to doing it any other way than a wet ink signature? In the context of a lockdown where you can't get to the client, how are you managing that at the moment, that sort of situation?
Yeah, look, that'll be interesting to hear how other practitioners are doing it as well. You know, when we've been forced to close our business premises, we've technically only been able to open for urgent type matters. So some of them can be an urgent matter where, you know, someone has death, you know, that's imminent and has not got an email or the ability to use the technology to have remote witnessing done. But it's causing a big problem for us, certainly in the aged care sector where, you know, you are prevented from going there, or the technology is not there, or the staff within the facility, you know, don't have time to set that up for the resident that's in there so that you can meet with them to get instructions at the very least. I've known some practitioners just sending out, you know, hard copies of the documents to clients to just say, even if you just put your signature on it, don't have any witnesses on there, just put your your signature on the document, and we'll prove it as an informal document at the very least. And Jenny sort of alluded to that, you know, we might not get hauled over the coals for that attempt, and the court might be sympathetic in the approach given the circumstances. So, but it's not ideal. It's not, there's no sort of one size fits all.
We've just had someone here. I'm sorry, I'll go to David in a moment, but Naomi, this is sort of right on point for you. Someone's talked about, you know, an informal will. If you had to choose between an unsigned will that was printed that, you know, you did the best you could to be sort of informal, or an electronically signed will, which would be your preference at the moment in terms of, if you know, taking one to try and get through probate? Which would be your preferred at the moment?
Well, the regs are there that supports the validity of an electronically signed document, so that shouldn't go through without with any requisitions. And it'd be good to get the court's take on that. We haven't, in Victoria at least, we haven't had anyone die as a result of COVID or during that COVID period where they've had an informal will or a remotely witnessed signed will yet. So we're still waiting for that test case to come through. But the regs are there to support the remote witnessing, even if they have fallen off the wagon and perhaps the last step in Victoria that's needed where it didn't get back to the will maker, it technically hasn't complied with the regulations. So technically then it would be an informal will. But I would be confident on that approach that the court would admit to probate that document, albeit being an informal will. The circumstances for an informal will where the regs aren't adopted, or we've just only got one witness or the will maker signing on their own. Each of those cases are decided by the court on a case-by-case basis, and the circumstances could be pleaded in the affidavit material about why electronic witnessing wasn't convenient or available or timely. I mean, some practitioners are not confident, I'm not the best of technical skills, so it's been a learning curve for a lot of practitioners to embrace the new technology, let alone Zoom, but to then talk about it with the clients to get documents electronically signed. So I think you'd be confident. I would adopt the approach that it's better than nothing. And to have something there, even if it's unsigned, you can still prove those. And you've at least adhered to most of the requirements for Section 9 of the Wills Act, which is the informal wills provision, which talks about it being a document, being testamentary in nature in terms of its content. And the only formalities it hasn't complied with it are the signing and witnessing. And you would be able to plead your case to say that, the instructions were taken by you. This isn't a self-made will where possibly others could have interfered with it or interposed themselves as being the will maker. And ultimately then the court would need to decide that.
Yeah.
I don't know if I've answered the question well.
No, you have. I mean, we probably should have a whole other panel session on and get the views of barristers and things. We've got actually a barrister we might hear from later, is a specialist in the space. But my having read a couple of informal will cases, I think it's probably fairly safe to advise clients that if you make an attempt with an electronically signed will, even if it's not accepted as a formal will, it's almost certain to be accepted as an informal will, because you've captured all the things you need to prove an informal will. And there's been far less formalised wills that have been accepted by the court as being informal and a will than what you've done with electronic. So I think you can safely say to a client, even if for some reason this doesn't get through the usual probate, almost certainly it will get through as informal, which is in some respects the same outcome, possibly just takes a little bit more effort and a little bit more cost. Thanks, Naomi. David, I want to throw, I guess, sort of the ethical dilemma that I think gets raised a lot by will specialists in this sort of space, which is the juggling of the responsibility of the will drafter and the will taker of instructions, and the responsibilities that the lawyer or the practitioner sort of assumes in that context around ensuring, and this is obviously often in the case of elderly testators, around duress and ensuring that they're acting, freely and there's clear instructions and that sort of thing, and even determining issues like capacity versus the process of getting the will executed. What are your thoughts, and I guess putting your ethics lawyer hat on here, around the sort of juggle that the practitioners embrace with that, particularly the sense that I can't do this electronically because I can't satisfy myself of all those sort of responsibilities?
Sure. Actually, before I answer that, if I could just jump in on the prior question that you asked, which was, given your choice, would you choose between a informal will or an attempt to use the electronic signing system? To be honest, I don't think I'd want to face an executor and tell them, oh, well, we now have an $8,000 to $15,000 application process because I couldn't get my head around the new regulations and didn't want to use Zoom. So if you haven't at least offered it, and you can't show reasonable grounds upon which the far end process couldn't be set up because of the nursing home situation or whatever, frankly, I think you've got some difficult questions to answer. And so I think the onus is almost reversed. I mean, if you're not meeting face to face, then you really do need to be using the system which is specifically set up to do this. unless you've got a good reason. And so I think that would be sort of my point. In terms of the ethics, to be honest, a part of this concern is that people have been going along to seminars for years, and the message that is rammed down the throat is, you know, lazy solicitors don't meet with their clients. And so, you know, if you're doing your job properly, you meet with them face to face, and then, you know, that gives you the ability to do all of these things. That's fine. But to be honest, I think when you really analyse what a solicitor's job is when drafting a will and witnessing it, taking the instructions and all the rest of it, a lot of that is pretty platform neutral. So it's about how the questions are asked, what is asked, whether the court ends up with a record that is usable at the end of the day that permits them to make an assessment of capacity as at when that document was signed. And let's face it, for 90+% cases, that's really just not going to be an issue. If, you know, whether you met with them in a coffee shop, whether you met with them, you know, met with them online, or they were in your office. I mean, it's black and white, and it's only really in the penumbral twilight cases where it might be questionable whether this is the best process. I don't think anyone's suggesting that an electronic wills or remote witnessing solution is best in every case. There will certainly be circumstances in which, you know, we have a slightly increased impediment to communication, and that's both ways. We don't see the client quite as well. We don't see their environment. The client doesn't see us quite as well. And certainly for elderly people who've already got cognitive problems, and, you know, they might have certainly capacity that satisfies Banks and Goodfellow, but they might not have it without, you know, a fairly careful process by which you communicate what they're signing. You know, you can't just leave them a written document, ask them to read it, and then expect that they're necessarily going to have the level of knowledge that that they need. So it's a careful two-way communication process. Certainly, there will be many cases where, you know, if you prop up a daughter's iPhone in the corner of a nursing home room, and somebody doesn't hear so well, doesn't see so well, and is dealing with these concepts for the first time, can you really expect them to understand what you're telling them? I think the answer is probably no. They're going to sit there and they're going to nod because they don't want to seem like a cabbage, but you know, there is that real question about whether that was the most appropriate method. Can you have an actual situation where, you know, ideally, I would hope that the nursing homes get on board with this and they set up video suites, 19-inch monitors, good audio systems, you know, the sorts of facilities which are really important to making sure that people at both ends can hear accurately. There's quite a few good resources around, actually, if you have a look. Queensland Law Society has got quite a good article on improving, on assessing cognitive capacity remotely using audiovisual systems, and we've picked up, and that was done by Judy Haywood, a colleague here. That picks up on, you know, quite a bit of research which has been done, particularly in nursing and around the telehealth system. And, you know, let's face it, I think telehealth is more challenging and complex than tele-law, and they've got to the point where they can do it. The sorts of things that doctors need to be able to see, you know, just somebody walking into the room, somebody's ability to stand up and do all of those, you know, motor things, not just answer questions, you know, they have those same challenges, and they can get around that. So I think the proposition that, you know, law is too complicated or law is too hard or capacity assessment is too difficult, really, I don't think that stacks up. Now, I think capacity is one thing. Undue influence is a little bit different, perhaps, because, of course, generally speaking, the twig that will tell an experienced solicitor that there's undue influence involved is not really what the client tells you. It's what you observe as the interaction between the testator and the, you know, the nosy daughter that's dragged her along sort of unexpectedly without an appointment. All of those extraneous things which tell you that there's something on that's going on in the background. Now, there will possibly be a case where, or two, where observations which were possible in a physical environment, which were not possible electronically, might mean that the odd case of undue influence is missed. But then again, let's face it, generally speaking, undue influence is a matter of time and fairly subtle pressure that goes on in the car park, in the car, and in the weeks leading up to the appointment. So it's, you know, I don't think that it's a good enough policy argument to say, oh, well, you know, there will be undue influence that sneaks through to block the entire community from a process, which is going to save them a lot of aggravation. And also I will point out that, you know, you guys from Melbourne, I mean, you live in a state that's the size of an IKEA car park. People in proper states, I mean, it can be literally an 8-hour drive to the nearest law firm, particularly as a lot of the smaller law firms in the smaller towns just aren't viable anymore. They're pulling out, and you can have to drive. I spoke to a fellow today, and it was an 8-hour drive to get a transfer document re-signed because somebody had stuffed that up. And you know, that sort of thing it's really not a trivial issue. And I don't think, you know, a slightly increased risk of undue influence in the very rare case really justifies putting people into a 16-hour round trip where that didn't have to happen. So, you know, both from a policy perspective and from a risk management perspective from the solicitor, I think those issues are live, but I don't really think that it's not something that we can circumvent. One of the suggestions I think that has been made that has some merit is that you bring the support person into the equation. So you don't, you know, you accept the fact that an older person certainly, or someone that's not familiar with the technology may need assistance, and that somebody will be sort of in the background and providing that. One of the things you can do is bring them into the equation, explain to them the importance of not jumping in and answering questions, the importance of letting people answer the questions themselves, the importance of, you know, genuine privacy, not just sort of retiring to the corner out of camera shot while mum has the chat, and even perhaps providing them with a declaration that they sign at the same time to the effect that, you know, these steps have been taken, that they were not present in the room, etc. And I think that might go a long way to a solicitor being able to show that they took a concrete and considered process to satisfying their obligation to be reasonably confident that undue influence wasn't a factor in a particular transaction.
Thank you, David. Jennie, I want to go back to something that David's first answer on the use of technology, I guess, and the positive obligation to embrace, you know, a regime that's there or offer it as an option. And I guess take it from the perspective of lawyers needing to upskill with these sort of things. You and I both know very well that the Supreme Court... Your
audio is terrible, Peter. You were doing the Darth Vader voice, I'm afraid.
Can you understand me enough to I can ask you a question about the break?
If I can, the way I'm hearing you is there a positive obligation to use technology? Is that the gist of the question? Yeah, that's good. Thanks for inviting me to speak, because I was going to say something about that. Yeah, look, I hear what David said about that instance where, you know, it's one of those instances where you're passing on your risk to somebody else. So if you're not confident using electronic means, and you know, your options are basically to refer the client to somebody else who is confident with it, or else if your client really wants you and wants to do it well, basically as an informal will, and run the risk of incurring a bill like that, then that would be something that you would have to discuss thoroughly with them and keep a very good file note. So I think, and I think also with the questions about any circumstances that might lead you to wonder about undue influence or any capacity issues, is very, very important to keep file notes to record all your observations of what happened during the meeting, and so that there's a clear record if a court has to look at that question in the future. So those the basic that's the basic shape of my response. But in terms of using technology, yeah, look, it's difficult to say that there's a positive duty for a lawyer to use technology, but the the issue is that as it becomes more ubiquitous and as more people use it and as it brings down prices and makes a transaction more convenient, it would be unwise for a lawyer not to upskill to make sure that they're using it properly, because they may well find themselves charging too much or being too slow compared to what's available on the market. So yeah, I think it's always a good idea to upskill as much as you can.
Can I just make
fabulous? Thank you.
That lawyers in the US do have an ethical obligation of technical competence. We expressly don't, and I'm not suggesting that we do. But certainly we are still fiduciaries, and one of the things we've got to do is turn our mind to ensuring that clients can get their legal work done at a reasonable sort of price. And, you know, if we don't want to use that system, that's fine, but we need to, I think, be upfront with people and say, there are others that do have a channel which is possibly better suited to you. I'll refer you to them, not just do it yourself old school and pass on the full cost.
Yes, exactly. And I think it's one of those things that's it's a bit of a sliding scale. There will be some things where you absolutely must upskill with technology because it's just too expensive not to use it. But yeah, look, it really depends on the circumstances. And yeah, I agree. There's no positive duty to be to get technological education. So that's been proposed by quite a number of people over time as a CPD requirement, but that hasn't been adopted in any Australian jurisdiction that I'm aware of at this point.
Although what I will say in Victoria, what I was going to say in asking the question, which you wonderfully answered telepathically, was that, I mean, in Victoria, the Supreme Court has a practice note around the use of technology, which has assumed that technology is the rule, not the exception, that reversed the onus several years ago, and which says that not knowing how to use the technology is not an excuse to not use the technology for the process if it makes for a more efficient process and benefits the parties. So strictly speaking, I mean, probate in Victoria falls within the Supreme Court. So there is an argument that practice note could be extended to apply to the probate and even the will processes. So I will say at this point that we're not going to talk about court processes today with electronic will. We have had some questions on that. The reason for that is we are going to devote a whole event on that topic as our next event, which we'll be holding hopefully on the 18th of November. We'll firm up some details, and everyone that's registered for this event will get a flyer for that. We have got our moderator, Paul Reynolds, lined up to talk to that event, and hopefully we've got some representatives from courts there. We might get Paul to have a word a little bit later when we're sort of wrapping up. But yeah, how these processes then are dealt with at the court level is obviously going to be a key thing for us. But interestingly, I think in Victoria, the Supreme Court is really keen to engage with practitioners and talk about the challenges that they are confronted with as much as we are. That's been great. Thank you, everyone. I think we're sort of reaching the point now where we might start to open things up a bit for our attendees to share some of their experiences or ask some of their questions. Everyone stay with me in the panel, and we might sort of jump in, and this is where things can get a little hair-raising with the technology. We've had some great comments made from people. I'm just going to give people some heads up. I might call on you to sort of share some of your experiences. So Carla, I think Talia, and I can't see their name here. Yeah, Talia has shared some great experiences, which I'll call in a moment, but to not throw you right in it, I might ask Inez, who is one of our attendees, and is not strictly on EWOC, but she is sort of honorary EWOC, and as far as I know, might be the first person in Victoria to have done an electronic will, because she actually went and did one in the first lockdown before in Victoria we had the COVID regime. And there's, I think what we're going to like to do is try and switch you on so you can talk. So I'm giving Sharon time to get you set up. And then would you be happy just to share your sort of experience with doing some electronic will processes? I know you've done several, probably more specifically since we've had the Victorian regime. So Inez is I-N-E-S, and I might see if I can give you the opportunity to talk because I can see your name right there.
The experiences could be good or bad, so, you know, they can be
yeah.
I've had clients where I've emailed them the protocol as to, you know, they've got a printer, they've got a scanner, we'll set it all up, and the clients have said, oh, this is all too hard, I can't deal with it, I'll wait till your office is reopened. And I think there's that mindset of this is all going to go away soon. So we'll just wait until, you know, it all goes away and the regs might not become permanent and we won't have to worry about it. We'll just do the traditional wedding. So, yeah, that's...
Thank you, Naomi.
Negative.
We've got an edge. What I'll say to everyone, by all means, keep your cameras off if you haven't, you know, been prepared for this and done the do or whatever. Inez has got her camera on and we'll be able to see her, but we'll switch you over so you can talk. But welcome, Inez. Please share your experiences.
Oh, hello, everyone. I hope you can hear me. Can you hear me?
Yes.
Oh, good. Excellent. I'm very sorry, but I kind of expected you to do that, but I'm on the walk with my dogs. So if they go off completely at the in a moment, I was prepared and brought my iPad. So anyway, thanks for giving me the opportunity. I certainly have done electronic will signing. In fact, I've done nothing but electronic will signing, and even applications, grant of probate, all electronically. And I have to say, I really enjoy the process, and I find that my clients enjoy the process. As some of the speakers have said before, it is it's just once you've got it sort of worked out how to do it, it's actually quite a straightforward process. People don't have to come into your office, which is obviously not possible in Melbourne at the moment anyway. I live in Ballarat. I haven't been to Melbourne for 6 months or so. You know, you can sign up clients overseas or wherever they are, and I think most clients enjoy the process, and I agree. I wouldn't do it with someone who has issues with cognitive, you know, cognitive issues or has borderline problems with dementia or something like that. But for the mainstream client, you know, in their, you know, who are able and who I know, or where I can be fairly confident that there are no issues of undue influence or lack of capacity, I think it's a marvelous way of doing it. I also agree that this additional pass the parcel step is a bit cumbersome, and I hope we can get rid of it. That is just sort of an extra thing that you have to explain, and that makes it a bit cumbersome. And the issue of, well, what is actually the original will, which I figure with wills is probably not too much of an issue, but when we get to powers of attorney, it is more of an issue. What is actually the original and who has it? But yeah, I can only wholeheartedly agree with what everyone has said, and thank you all for sharing your views, because it has just very much strengthened me in my opinion that I think this is the way to go, and particularly that we don't have to be too scared in case something goes slightly wrong. Good file notes and making sure that clients understand what you are doing is, I think, essential. But in these kind of times, we need to do what's necessary as good as we can do it. And yeah, I'll just really hope that we can learn from this and keep on going with it. Not for every client, as we've said, but as an extra tool in our toolbox to make it efficient for people who can't come to the office. And I heard the comments about Victoria before and the IKEA car park. I mean, I'm in country Victoria, and there are still people who are, you know, very quite far away from the office and who can't make it, and for them it would be just marvelous if they could just sign their wills like this. So thank you for the opportunity. Beautiful.
Thank you, Inez. Sorry for putting you on the spot. By all means, everyone, you don't have to turn your cameras on. Keep trying to walk, but thank you. That was fabulous. We might ask, Carla has made a comment about a sophisticated but physically disabled client who would prefer this sort of regime. And Carla's also asked us a question about sort of the process of trying to do this without access to a printer, which we've sort of spoken to. And I mean, my answer to that is to use a system like a DocuSign. And by the way, I talk about DocuSign a bit the way we talk about Kleenex. I'm not endorsing it as the system that everyone should use, but it's sort of the dominant system, and it's the one I'm familiar with. But when I say DocuSign, I mean a purpose-built electronic signing system, which definitely allows the witnessing and execution to happen without you having to print anything. That's the entire point. And actually, just before I throw to Carla, and I'm giving Sharon some time to find Carla and bring her up, but one of the things, Naomi, that you know, I think dealing with the Victorian regime, that when you sign with DocuSign in real time, you actually see people signing. So I did it with clients recently where we had 4 parties all signing, and we decided to do it via Zoom because I was actually witnessing it with a deed. It wasn't a will. So I had to watch them all, and they all, like, they were sort of in their sort of late 60s, and they were so excited when all these signatures popped up on their screen. Like, as each person hit the button in all their different computers, all the signatures popped up, and they were finished with the fully signed document in front of them. So it happened in real time, and I think if the drafters of the Victorian regulations experience that system, they might realise that sort of the pass the parcel is completely unnecessary if you use a system like that. All right, Carla, have we got Sharon, Carla there to be able to talk? Yes, we do. Fabulous, but you're on mute. Come off mute, Carla. Share your experiences with us.
There we go. Yes, thanks, Peter. Look, I've got a client who, she's a bit of a disability advocate. She has a number of conditions that means that she is bedbound a lot of the time. She's the sort of person who's given testimony to the Disability Royal Commission recently, basically puts herself out to speak on behalf of others who are in a similar position, at some personal cost to her, because obviously due to her her disabilities, each time she does that, it increases her level of personal exhaustion. For her, she's found a lot of the telehealth and the remote witnessing to be a boon, because she has access to services that she would not normally be able to get access to without that personal cost. I've signed a statutory declaration with her using the, the pass the parcel method. But we were sort of looking, I guess the question was how we deal with that signing via DocuSign. Can we do it that way? And, given that there are a lot of reports coming in of those people who might have contracted COVID-19 but have survived and have perhaps some long-term health issues as a result, including almost disability-like effects, I think this is probably going to be a process that will be extremely useful for those clients, because they might find that their ability to get out of the house, whilst they can do it, it's going to leave them physically and mentally exhausted. So that I think that's going to be a real boon to a lot of our client base that, might be ones that we've struggled to connect with in the past.
And to that,
thanks,
Carla,
thanks.
Whilst we don't have a vaccine yet, and that may be some months, some years beyond, before that's available, there are clients out there who are immunosuppressed or who are compromised in some way, that even once the regulations, once the stages or the restrictions are lifted and we can open up our premises again, that remote is just going to be the best and convenient way to still communicate with them and service them, rather than forcing them to come into the office. Well, you must come in and see us face to face, and we must see you, and have them have that anxiety about possibly catching the virus when they're already suppressed or compromised in some way.
Thanks, Naomi. Carla, can I ask you, are you familiar with an online signing system? Have you used it in other contexts?
I have, yes. I've used DocuSign primarily in my property law practice, but and I hadn't used it in this this particular occasion because the client had the ability to print and sign. But the other thing, I also would have found it quite useful in terms of dealing with a client who I also had to do a statutory declaration for, who also has some physical disabilities, and he struggles to make his wet signature consistent, to the extent that he was known to joke that his signature was somewhat like a fingerprint, no two are alike. So for him, the ability to sign via DocuSign, where there can be a recorded signature and can meet that consistency, is certainly an advantage for him. Yeah,
fabulous. Thank you so much, Carla. Thank you for jumping on and sharing your screen as well. That's great. We might also now go to Tali, who has also shared an experience in the aged care environment. Now, Tali, you've actually shared sort of two stories. Happy for you to share both. You've typed them out. It'd be great if you're happy to sort of jump on and talk about those experiences. One, I think, that you've had from a colleague, and I think the aged care environment is one that is a really a key one that as Naomi talked about. Whilst on the one hand, there can be challenges around access to and ability to use technology. And yes, Tali Fletcher, but also the, but it can also be an opportunity. I mean, where people are immunosuppressed that are concerned or not able to or not wanting to have access, this can be the solution, as we heard from Carla there. So, Tali, have we got Tali? Yes, we have. We're not going to have camera, that's fine. Welcome, Tali. Please share your experience.
Hi, thank you. Yeah, sorry, I'm not dressed for for the occasion, sorry. I was just commenting in relation to whether it was sort of a better idea to go with an unsigned will or an electronically signed will, and share my experience on that. We had a case at my firm where it wasn't me, but a colleague had a client in an aged care facility right at the start of the first wave in Melbourne. We had an appointment booked for him to sign the will and come in, and then first wave hit, so he wasn't allowed to leave the aged care facility. So he called and cancelled the appointment, said he'd rebook when he's allowed to leave. And then unfortunately he passed away shortly thereafter, so he never got to sign his will. I was involved in the process of trying to admit that will to probate, but it seemed that the court was not really keen on they didn't really want to admit that will to probate because it wasn't signed. So we explained the circumstances, and it appeared pretty clear to us that he wanted that to be his last will, but the court didn't really agree with that. So yeah, that's essentially it.
Have they made a decision on that though, or not?
The client, it's a small estate, so the client's instructed us not to proceed with that application because we can't give the evidence that they've asked us to give. So we explain the circumstances, and they've essentially said, well, yes, but what was his intention that he wanted to sign that will? Well, we've already provided everything that we knew about the circumstances, so if there's anything more, we really can't proceed. Does that make sense? Not really.
Yeah, I mean, the registrar's powers have been recently expanded to allow the registrar not have it formally going to flipped into the Supreme Court for a judge determination, but the registrar of probate is able to assess informal will applications where the estate is valued at under $1 million. Mm-hmm. So that's where it would just be strictly at the registrar level only that they would assess that. But each of these informal wills are going to be on a case-by-case basis. I'm surprised by what you've said, Tali, in the sense that the court wasn't receptive to that, given the circumstances. But that's not to say that something, that's not to say that, with further evidence or, different evidence or another set of circumstances before the court, you'd get a different result.
Yeah, it was a bit surprising.
Tali, I suggest you come along to hopefully our next event, and we might even have the acting registrar of probate for the Supreme Court to be able to talk to those sort of issues. What I think is going to be the case with the court is that I think they're going to prefer that practitioners are following the regime rather than going down the informal path, because that actually really greatly increases the administrative burden on the court, aside from practitioners. I mean, to David's point earlier, that it's also going to increase the cost for the clients, but I think they definitely would prefer where there's the choice, when you can't do weddings, that you follow the regime, and because they're going to have a process set up for that. Interestingly, and Inez mentioned before that she had been through an online lodgement process. The court confirmed to us, the Victorian court confirmed to us, that they haven't yet had an electronic will lodged for probate. So that moment is still to come, but it's inevitable. I think it will come. Thank you, Tali. Thank you for participating and sharing your experiences. We've got a question here, and I'm just wording up Kimberly Martin as the next person to talk, but we've had a question here raised by one of our attendees about, I guess, Australia being a bit of a late adopter here. And I guess it's important to appreciate that we're not sort of completely at the tip of the spear with this sort of thing. That electronic wills have actually been around in other jurisdictions for some time, well before COVID. In fact, it's been legislated in some regimes. And we're very lucky to have Kimberly, who is another EWOC committee member and is our resident international electronic wills guru. For those of you who haven't joined our Facebook group, please do. I've got a lot of you that have joined, and Kimberly wrote a fantastic, very detailed paper that we've shared on that Facebook group. But Kimberly, maybe if you could just give us a bit of a snapshot of some of those jurisdictions that are leading the way with this, and what they've sort of done, and I guess some of the learnings that we could take here in Australia with some of those experiences.
Absolutely. Hi again. I wasn't expecting to be called upon, so but look, the paper itself, which is available also on LinkedIn and on Facebook, discusses the history of it. And the history is that this is something that's been debated in the UK, in the US and in Canada for quite some time. The US is the jurisdiction that has led the discussion in relation to electronic wills, and they have legislation and had legislation for some time. The problem that I suppose exists and what we're experiencing in only really coming to terms with this as part of the COVID-19 is the fact that the technology itself, just because we click our fingers and we say, well, now we're ready for electronic wills and all of the considerations that come with them, it doesn't mean that the law is ready. The law is incredibly, I suppose, old school in the way that it adopts new technology. And what we can do is we can look at what's happening in the US and in Canada and at their legislation and at the protective mechanisms that they've implemented in their legislation, and the practice guides that have been put out. One of the things that the paper does is it looks at every jurisdiction around the world currently that has implemented or introduced temporary legislation for electronic wills, or that have permanent legislation, because Canada and the US both have permanent legislation, not temporary legislation, that allows electronic signatures to be used in the execution of wills. And that's quite different to the discussion that we're having in Australia, which very much centres around the remote witnessing of documents. Victoria being the only jurisdiction that contemplates the use of electronic signatures, but it's not easy. But I think one of the most important things to stress is that it's not going to go away. If you compare it to the introduction of electronic signatures in commercial transactions globally, what happened when electronic signatures first started being used in e-commerce was you had countries all over the world coming up with their own legislation and their own regulations, and then we had bodies come in and try to introduce common ground amongst each of the jurisdictions to ensure that there was some consistency and that people could interact and trade using electronic signatures. I don't think it's going away. I think now that people have had a taste for it, and particularly given the increasing appetite for the implementation of technology in all aspects of our lives. I'm sitting on a panel soon based in Canada, and they're interacting with technology experts to talk about what sort of technology, what changes have to be made to the DocuSign and to different technology that we can implement to deal with wills. Because when DocuSign was set up, it wasn't set up to contemplate electronic signing of wills. It was set up in very different circumstances. And so what has to happen is people who are working in this space and people who are having experiences with the problems really need to be involved and communicate their concerns and their jurisdictional based issues, because we all work in different jurisdictions. I'm in Tasmania. We don't have legislation that allows for remote witnessing of wills or for the use of electronic signatures in wills. But every jurisdiction in Australia has a different system, and it's shown by the fact that there was no integration, there was no support amongst jurisdictions. And I think as Australian practitioners, we have to encourage that, because there will be issues. If you are in Victoria and you're on the border, with South Australia, can you use the Victorian legislation for a client who is in South Australia? Can you use legislation across jurisdictions? And speaking with the Registrar of Probates in Tasmania recently, one of the issues was, can you in fact witness documents via electronic signature under the Victorian legislation if you are in a different jurisdiction? And that is a question that is yet to be addressed. So if you've got clients and they're in, they're overseas, or even if they're in Victoria and I'm in Tasmania, my current approach would be, I would be very hesitant to witness the documents electronically because I'm not sure that it would comply with the relevant regulations.
Well, that question even goes further, Kimberly, that what is the relevant legislation? If all the parties are in different states and you're signing in cyberspace, what is the location? Like, I mean, I think probably you'd say it's the location of the testator for a will, but that's itself an uncertain question. Someone raised the question about the need for harmonised legislation for these sort of things across the country, and that issue in itself, begs, what if we had the same laws across the country adopted by all the states and federal, then we wouldn't have to worry about that problem. We could be aware of it with the same regime. Thank you, Kimberly. So, Willis, we hopefully might have you actually as a panelist at one of our future events. Thank you for coming up without warning. Appreciate that.
I'll just say one more thing, and that is that even if we're in jurisdictions where you don't have the legislation, don't think it's not going to affect you, or that you don't need to be familiar with it, because it is absolutely possible that a will that was executed under the Victorian regulations could be brought to a Tasmanian practitioner for a reseal or for a grant of an application for a grant of probate. So it isn't just Victorian practitioners that need to be familiar with it. It is possible that other jurisdictions will have to deal with it if we receive instructions to do so. Great, thank you, Kimberly. All right, we're getting into the final straight. I'm going to try and make sure we finish very promptly at 6:30 because we've all got families to go and have dinner with. I'm going to throw to Paul Reynolds next, but just before I do, we've had one question that I think I'd just like to answer and make sure we've covered off, because although we are the Electronic Wills Committee, we're also the Online Witnessing Committee, and we do need to pay attention that there is sort of broader issues than just wills. And one person has asked about the question of deeds, and that's a really good sort of question to ask. And I just wanted to point out that there's sort of two problems with electronic deeds. There's the witnessing side of it, and by and large, the regimes that we've talked to have dealt with that. So I mentioned New South Wales. It specifically talks to that you can witness a deed in the same way that electronically, the same way as you can do wills, etc. But there's another problem that the law around deeds is actually based on the common law, very, very, very ancient common law. And the view is that the common law itself requires the deed has to be on paper, parchment, or vellum. And therefore you can't actually execute, according to the common law, a deed electronically because it hasn't been created in paper, parchment, or vellum. Now, in Victoria, the COVID regimes addressed that and said very explicitly that a deed can be solely electronic, and that overrides the common law. So for the moment, in Victoria, we can both have an electronic deed and it can be witnessed according to the regime. I'm not sure that problem's been fixed in New South Wales, in that whilst you can witness it electronically, you might not overcome the common law problem. I've got no idea what the regime is in Queensland. Interestingly, the Commonwealth Government is also live to this issue, specifically in the context of companies and the Corporations Act. And I think that the issue will be addressed from a company's perspective in the near future, so that companies will be able to sign deeds electronically pursuant to the Corporations Act. So I think it's a space everyone's got to just sort of watch. At the moment in Victoria, yes, you can. I'm not so sure about other states, but you've got to draw the distinction that deeds are their own little special category a bit. Everything else at the moment, so stat decks and affidavits and wills, etc., we have pretty good guidance around. We've got 5 minutes to go.
I will just butt in there. Electronic deeds are expressly recognised in the Queensland reg, so.
Beautiful, yeah, so we're fine. And in terms of overriding that common law requirement?
Well, I hadn't looked at it from that perspective, but I would think that a regulatory instrument which expressly says that an electronic copy of a deed is recognised is going to overcome any common law problem, yes. Yeah,
great. Thank you, David. All right, I've got Paul, and then we'll wrap up. I might try and let Paul finish, give everyone a couple of minutes just for their sort of closing thoughts, just a heads up for David and Jennie and Naomi, and then we'll wrap up. But welcome, Paul. Thank you for joining us. Paul's one of Tammy's barristers and will be the moderator of our next event talking specifically about the electronic wills and online processes in the court side of things. Welcome, Paul. Did you have any sort of reflections? And I guess in the context of I think a theme that we've been grappling with here about the why bother with all of this. Is this stuff going to be here post-COVID? Is this something that we might all have to recognise could be something that's going to stay in some form or another? And obviously at the bar, you've had your own experiences with using tech in the courts, and there's been a massive learning curve for judges and barristers and solicitors alike. What are your sort of thoughts on this all?
Yeah, so the thing that really struck me this whole way through, because I'm just working on an informal wills matter at the moment, and yeah, it really strikes me that I wish that this legislation was around when the testatrix made her will, because we're trying to admit an iPad will to probate. And that's proving difficult because there are multiple versions in multiple iMessages across the place with different timestamps. And, you know, we've of course got to prove the knowledge and approval aspect and the testamentary capacity aspect. And I just thought if we had a video of her signing it, and the court can actually, or the registrar as the case may be, could actually see that sort of active adoption, which sounds like it might have been the problem that Tali had in her matter, then that would be really beneficial. Obviously, it's not the first resort to go to the dispensing provisions, but I think it could have really beneficial flow-on effects and perhaps mean that some unnecessary litigation can be prevented. But yeah, those were really my thoughts. But I confess I haven't had an electronic will come before me yet. So
no,
yeah,
that's
something I look forward to.
I think that's fair enough, but I think give it time.
Yeah.
Yeah, look, thank you, Paul. And look, I think this is something that I realised with it. I felt this with electronic documents for a while. The evidence that is gathered by the process is significant. I mean, we've talked about using a Zoom and a DocuSign, and you actually have the ability to record the process as you do it. So not only have you got the document signed, but you've got a recording of it being signed, all captured. You've got metadata around where people were because you can capture. There's so much evidence. I mean, you know, from a protection of our position as practitioners, we've got so much more evidence than we would have ever before in a wedding environment, which, as you say, will make the job of barristers and the courts a lot easier. So, yeah, lots of things to embrace there. Thank you, Paul. Look forward to your session in 6 weeks' time or so. Thank you for your time. The last couple of minutes before I sort of wrap up, I might just throw to Jennie and to David and Naomi for their sort of final words. So I guess your final sort of reflections on our discussion today. It's been great to have everyone's insights. Jennie, maybe to you first of all.
Oh, look, I just wanted to say how excited I was, particularly by Carla and Inez's stories. That I think there are so many possibilities that technology gives to improve access to legal services. And particularly Carla's experience with clients with a disability, I think it's fantastic that they can use these systems so easily. And so I think there's enormous possibilities. And as the regulator, we're very, very keen to ensure that lawyers can use these tools confidently and for the benefit of their clients. So yeah, great session. It was a privilege to be part of it. So thank you.
Thank you, Jennie. Thank you. That was fabulous and appreciate your contributions there. David, your final reflections.
Yeah, I'd endorse that. I also think, you know, on the whole, as a profession, we've almost priced ourselves out of the middle market, middle Australia's market. Obviously not for fixed price wills, but for everything else. I mean, we've really got to start to look at ways of bringing costs down, and it's just not fair if we pass on those costs back to people who, you know, get up and clean houses for a living if they need legal services. So I think, you know, there is that fundamental line that says we've really got to get our finger out in terms of making sure that we're looking for all of these cost-cutting opportunities. Just on that one point in relation to the capturing of the evidence, it is actually something that solicitors got to turn their mind to in the practicalities. We're strongly encouraging people to actually download MP3 and MP4 files, pull it back into your practice management system, work out how to do that, and don't just rely on you having access to Zoom accounts, you know, in 10 years 10 years time, when you actually need those. And there's some, you know, some practicalities to get your head around, you know, but it's all pretty soluble. So I'd like to thank you for the session today. I thought that it worked quite well. Australian Cyber Law Institute is looking for members, and I think, you know, the success of the last two events really brings across the fact that it's an organisation which has a great deal to offer and a great deal of merit. So whether your interest is technology generally, technology and the law, or you know, more specialised subset, please consider membership, and we'd love to have your contributions going forward.
Fabulous, thank you, David, and thank you for the ACLI plug. I was going to do the same. I think what you've raised there around the issue of capturing the data is a whole ACLI session. I think we should probably do that. EJ Wyatt, our president, will be all over a lot of the issues around that. I'll let Naomi have her final say, and then I will just talk a little bit to ACLI and to our future events and being further involved. So thank you again, David. Naomi, your final reflections.
Look, I'll be brief because I know we've gone over time now, but look, I think the regs, I think it's highly likely they're going to be extended again come 24 October when they're due to sunset, in all likelihood. And there is merit for them in going beyond that, and this isn't just a temporary measure, this is going to be a permanent measure. So practitioners should be, you know, getting up to speed with the technology and not giving up that competitive advantage that they might then have. Property solicitors had to embrace when the PEXA platform became available and everything went online there for property transactions. And I think it's just going to be a natural flow on that in the personal private client space, that wills is now going to be available not just for remote witnessing, but for accessing lawyers on a remote basis to give will instructions. And we've seen that there's been lots of advantages: regional, rural, people with disabilities, elderly, clients that are time poor, so, you know, that they can access lawyers online and be able to then have the witnessing done. So yes, the regs are probably here to stay. Should we still bother? They're not ideal at the moment. I'm certainly not a fan of them, particularly that last step in the pass the parcel stage, but we're going to get our head around the DocuSign type platform that seems to get around that issue. So there's certainly room for improvement, but yeah, I think that practitioners should be knowledgeable now and offering that as a service for their clients, and not just avoiding it as a wait till we reopen message. Great.
Thank you so much, Naomi. Thank you for your contributions to that. It's been fabulous. I'll leave Carol to have the final word and say some thank yous, but I just want to sort of give two sort of final plugs. The first, as David mentioned, these events are free, and will hopefully continue to be free. Very appreciative of Tammy's support. There are some costs involved in putting these events on, even virtually, and Tammy's support enables that. But the activities of the Australian Cyber Law Institute, including the activities of EWOC, will require some resourcing, and your way of supporting that is by joining up as a member of ACLI. If you go to the ACLI website, you can find your membership application form at hopefully very good value for the content. We will make all the resourcing and content that we have generally available free, so your membership sort of helps sort of fund all of that. So please look to that. In terms of EWOC itself, the best way to get involved with us at the moment and to avail yourself of our resources is to join the Facebook group. So if you search up EWOC, or Electronic Wills and Online Witnessing Committee on Facebook, and where sort of you have to apply to join, but we are accepting all takers at the moment, and then that will be where we will put resources and encourage discussion and follow through on all of this. You'll all receive information about our future events that you're now on our list. So thank you very much for everyone's participation. I'll let Carol have the last word, but the thank you that I'll say is thank you, Carol, for your efforts in helping getting EWOC up and running and being a powerhouse of energy and building some new relationships. So thank you also for your efforts today on top of everyone on the panel. So thank you.
Well, Peter, thank you very much. What a wonderful event. We've been so blessed to have, you know, my committee colleagues, Anne and Naomi Guyett speaking today, you know, one as moderator and one as panel, and, you know, representative from the regulator, Jennie Pakula, who's just been wonderful in guiding us about how we're going to, or how the regulator might deal with our future electronic wills, oopsies, and David Bowles, a member of the board at ACLI, and also, you know, our ethics brain for today. We look forward to having many more conversations with everyone, and thank everybody in the audience for spending your time with us. We look forward to a continued relationship with you. We'll see you on the Facebook page. Thank you and good night.